OSH code, the Occupational Safety, Health and Working Conditions Code. Four labor codes: Code on Wages, Industrial Relations Code, Social Security Code, and the OSH code are set to consolidate and replace 29 labor laws. All four codes became operational on November 21st, 2025. Their implementation in the states is awaiting passage of rules from the respective states. The OSH code replaces 13 major central labor laws. Prominent among them are the Factories Act, Mines Act, Dock Workers Act, Plantations Labor Act, and BD and Cigar Workers Act. The OSH code is expected to be a single consolidated framework aiming to reduce complexity and also improve compliance. The OSH code specifies its coverage in terms of four sectors. First, any establishment where any industry, trade, business, manufacturing, or occupation is carried on with 10 or more workers. Second, a factory where at least 20 workers with power or 40 workers without power are engaged in operations. Third, all mines and docks. And the fourth sector, any establishment carrying out hazardous activities regardless of the number of workers involved. The first sector, establishment with 10 or more workers, required to register within 60 days using the Shram Suvidha portal. Establishments which are already registered required to update their details within a prescribed time frame. Employers must notify the registering officer when they are starting operations. If an establishment closes, the employer must inform the officer within 30 days of the closing, also certifying that all dues to workers have been paid. And it is mandatory to issue a formal appointment letter to all employees, including those employees who have been hired before the code. The code is applicable to the second sector of factory. A factory is a premises including precincts thereof, in any part of which on any day in preceding 12 months a manufacturing process is carried on using power and 20 or more workers, or without power and 40 or more workers, taking all shifts together. State government is empowered to make rules on approval, licensing, and registration of the said factories. The manufacturing process as related to a factory includes four types of industrial activities. The first type, core activities of making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, or demolishing any article or substance for the sake of usage, sale, transport, delivery, or disposal. Second type of industrial activity of utility and infrastructure involving pumping of oil, water, or sewerage, and generating, transforming, or transmitting power. And the third type of industrial activity of modern printing, comprising offset, screen printing, 3D or 4D printing, or prototyping, and flexography. And the fourth type of industrial activity related to manufacturing process is storage, the activity of preserving or storing any article in cold storage. The code defines the term worker as a person employed for skilled, unskilled, manual or technical work, but it specifically excludes those in managerial or administrative roles earning wages in excess of rupees 18,000 per month. It also defines wages as including basic pay, dearness allowance and retaining allowance. Wages excludes items like bonus, HRA and overtime. It stipulates that if the exclusions exceed 50% of total remuneration, the excess is added back to wages for statutory calculations. The code defines hazardous or life-threatening activities as any process or activity in relation to an industry specified in the first schedule to the code where, unless special care is taken, raw materials, byproducts or wastes of such process or activity cause material impairment to the health of persons engaged, and it also pollutes general environment. The list of 29 industries involving hazardous processes in Schedule 1 to the OSH code duly note the potential risk of bodily injury, poisoning or disease to workers. As the basis for inclusion in the list, the industries listed in the schedule broadly comprise manufacturing, processing and treatment operations, metallurgical and foundries, chemical and allied units, and also include handling of highly flammable liquids or gases. Multiple mandatory compliances are specified in respect of hazardous processes. Before starting a hazardous process, employers must conduct a risk assessment and obtain prior approval from the relevant authorities. The establishments must maintain a mandatory on-site emergency plan, conduct mock drills every 6 months, and coordinate with the local disaster management authorities. The employers must also provide compulsory training on the safe handling, storage, and disposal of hazardous materials. The workers have a right to obtain information regarding safety and health standards from their employer. For factories in hazardous processes with 250 and more workers to form a safety committee. Free annual health checkup are mandatory for all workers in hazardous processes. Employers must maintain digital health records which are accessible to employees and inspectors for long-term portability. Workers also have an explicit right to refuse work if they reasonably apprehend imminent serious injury or death, with zero penalty for the refusal. Violations in hazardous processes carry up to 2 years imprisonment or a fine of up to rupees 5 lakhs. Section 6 specifies the duties of the employer. He shall ensure the workplace is free from hazards that could cause injury or occupational disease. He should organize safe disposal of hazardous and toxic waste, including e-waste. The employer should adhere to prescribed safety and health without charging the employees for the safety measures. Designers, manufacturers, importers, and suppliers of a factory must ensure that articles and substances for use therein are safe and do not pose a health risk. Similarly, professionals involved in building or construction projects must integrate safety and health aspects into the planning and design stages of a factory. The code casts three specific duties on employees. One, to take reasonable care to ensure own safety and the safety of others who may be affected by their actions. Two, mandatory reporting of any unsafe or unhealthy situations either to the employer or health and safety representatives. And third, send timely notices to prescribed authorities in the event of accidents resulting in death or serious bodily injury or dangerous occurrences, specifying the types of incidents, whether or not they cause injury, and occupational diseases, which are specific diseases contracted by workers as listed in the code's third schedule. Five sets of health and welfare measures to be taken by the employer. First set, mandatory health checkup. Employers must provide a free annual health checkup to all workers aged above 40 years. Mandatory pre-employment, periodic and post-exposure medical examinations required for workers in hazardous industries, mines and plantations. That no charge is levied on any employee for medical examinations or investigations intended to detect occupational diseases. Second set of health and welfare measures from the employer pertain to workplace hygiene and environment. Provide separate washing facilities, locker rooms and washrooms for all employees, including transgender. Workplaces must be free from dust, noxious gases, fumes and other impurities that could cause occupational diseases. Providing wholesome potable drinking water is mandatory for all establishments. Adequate lighting, ventilation, and a hygienic work environment free from overcrowding is expected. Proper sitting arrangements for employees who are obliged to work in a standing position is essential. Third set of health and welfare measures under welfare and medical facilities. The number of working hours capped at 8 hours per day and 48 hours per week to ensure work-life balance. Establishments with more than 50 workers must provide creche facilities for children under 6 years of age. Canteen provided for establishments with 100 and more workers. One first aid box to be there for every 150 workers. Appointment of welfare officer mandatory for factories with 250 and more workers, and ambulance rooms mandatory for factories with 500 and more workers. Occupational disease management, the fourth set of health and welfare measures. Employers must notify relevant authorities if a worker contracts any of the 29 specified occupational diseases listed in the third schedule of the code. Any medical practitioner attending to a worker suspected of suffering from an occupational disease must report it to the chief inspector cum facilitator. Health and medical records must be maintained digitally, ensuring transparency and long-term portability for workers. Establishing safety committee is the fifth set of health and welfare measures. A safety committee to be set up for factories with 500 and more workers, and for hazardous processes for 250 and more workers, with equal representation for employer and worker. The committee is responsible for monitoring workplace safety and health standards. Certain specific provisions on working hours. The code caps work at 8 hours per day and 48 hours per week. The daily workday, including rest intervals, must not exceed 12 hours. The employer need to obtain consent of the worker before assigning overtime. The quarterly overtime limit is capped at 125 hours. The overtime wages are required to be at double the ordinary rate. The code restricts workers in factories and mines from being required or allowed to work if they have already worked in a similar establishment within the preceding 12 hours, and bans double working. Certain provisions of leave and leave encashment as per the code. Workers are eligible for paid leave after 180 days of work in a calendar year. The accrual rate is 1 day of leave for every 20 days work. An employee can carry forward a maximum of 30 days to the succeeding year. However, any refused leave has no carry forward limit. An employee can encash unavailed leave exceeding the 30-day carry forward limit at the end of each calendar year. Upon separation, that is resignation, dismissal, death or superannuation, the employer is required to pay all pending leave in cash within a period of 2 months therefrom. Certain specific provisions in respect of employment of women. Women are entitled to be employed in all establishments for all types of work, including hazardous processes like underground mining, heavy machinery, etc. Women also permitted to work between 7 p.m. and 6 a.m. with their explicit consent. The employer is required to provide safe transportation, lighting, CCTV surveillance, and separate rest and sanitation facilities. Pregnant women, however, are strictly barred from engaging in certain hazardous processes. Women to have adequate representation in central and state advisory boards and also on grievance redressal committees. Certain special provisions in respect of employment of young persons or adolescents. An adolescent is defined as a person who has completed 14 years but not 18 years of age. Adolescents are prohibited from being employed in any hazardous process or dangerous operation, required to carry a certificate of fitness granted by a certifying surgeon after a physical examination. No young person is allowed to work on dangerous machinery unless they have been fully instructed on the risks involved and are under the supervision of an experienced person. Adolescents are permitted to work for not more than 6 hours per day, including rest intervals and waiting time for work. Employment of adolescents is prohibited between 7 p.m. and 8 a.m. The total working hours must not exceed 36 hours per week, and young persons must not work for more than 3 hours continuously without a break of at least 1 hour. Employers are not permitted to require or allow adolescents to work overtime. They must be granted 1 full day of holiday every week. They are entitled to 1 day of leave for every 15 days of work. Employers must maintain a register detailing the name, date of birth, nature of work, and hours of work for every adolescent employed in the establishment or factory. Within 30 days of hiring an adolescent, the employer must send a written notice to the local inspector with details of the establishment and the nature of the work. The certificate of fitness required to be carried by an adolescent is issued by the certifying surgeon. The certificate is valid for 12 months. It is issued against application by the candidate along with an employment proposal from a factory or establishment. The certifying surgeon claims the fee from the factory or occupant. The certificate may be revoked by the surgeon anytime for valid reasons. A certifying surgeon is a qualified medical practitioner duly appointed by the state government. He is appointed with such local limits or for such factory or class of factories with a set of duties such as examination and certification of young persons, examination of persons engaged in factories in certain dangerous occupations or processes, and he may be required to exercise such medical supervision as may be prescribed for any factory or factories. Certain special provisions in respect of contract labor. The provisions apply to establishments or contractors employing 50 or more contract workers on any day in the preceding 12 months. Employment of contract labor is generally prohibited in core activities of an establishment, with exceptions for sudden surges in workload or activities that do not require full-time workers. Core activities are the primary activities for which an establishment is set up. It includes activity essential or necessary to such primary activity. Specific exceptions are made for support services like sanitation, security, and catering. Contractors employing 50 or more workers must obtain a single All India license for 5 years to engage contract labor through the Shram Suvidha portal. The principal employer is responsible for providing welfare facilities like health and safety measures. If a contractor fails to pay wages, the principal employer must pay them and later recover from the contractor. Incidentally, a principal employer is the person or entity that has ultimate control and supervision over an establishment where the contract labor is engaged. The code makes special provision in respect of migrant workers. Migrant workers include workers who come on their own to another state and earn up to rupees 18,000 per month. Employers must pay a lump sum journey allowance once a year to migrant workers for travel to and from their native place. The employers must ensure that the migrant workers can access the public distribution system and insurance and provident fund benefits in either their native state or in the employment state. The government is required to maintain a database of these workers to ensure they can receive their entitlements through self declaration. The government is required to provide a toll free helpline for grievance redressal for the migrant workers. The code envisages constitution of two types of advisory boards. National Occupational Safety and Health Advisory Board is constituted with representatives from trade unions, employer associations, and state governments. It advises the central government on standards, rules, and policies for various industries, including factories, mines, and docks. State Occupational Safety and Health Advisory Board, the state counterpart, advises on occupational safety and health matters specific to the state jurisdiction. The primary role of these boards is fivefold: to develop and harmonize safety standards across the country, to recommend mandatory quality standards for occupational safety and health that all states must follow, to advise on the formulation and implementation of programs related to worker well-being, to guide the government on procedures for safety audits and hazard assessments, and to streamline safety regulations for balancing worker protection with the ease of doing business. The OSH code facilitates decriminalization of many minor offences. It also gives employers a mandatory 30-day notice to comply before any prosecution. It facilitates compounding for first-time offenders, permitting settlement of cases by paying 50% to 75% of the maximum fine. Courts are permitted to direct that at least 50% of fines imposed be paid as compensation to the victims or their heirs. Further, disputes under the code are handled only by the prescribed authorities under the OSH framework, explicitly excludes the jurisdiction of civil courts in matters governed by the code. The code introduces a social security fund to be set up by the appropriate government for the welfare of unorganized workers. A significant portion of the fund is financed by the amount collected through compounding of certain offences. Fines and penalties imposed by courts are credited to this fund. Government may also specify additional sources such as grants or contributions from other welfare funds. The aim of the fund is the welfare of unorganized workers on health benefits, accident insurance, and life cover. The code envisages a paradigm shift in the role and importance of inspector. The traditional inspectors are sought to be replaced by facilitators who use a randomized web-based inspection system to provide guidance before initiating enforcement. Inspectors are now required to provide information and advice to employers and workers on how to comply with the code very effectively. The facilitator model encourages voluntary compliance, giving employers a 30-day window to rectify non-compliance before any legal action is initiated. The responsibilities of inspector cum facilitator includes inquiring into accidents, conducting inspections, and ensuring compliance with safety and health standards.